Hello, today I'd like to talk to you about one issue from one case taken from Chapter 4 of the book, True Patent Value, Defining Quality in Patents and Patent Portfolios. I hope this example helps you understand what the book is about. The example involves litigation between Broadcom Corporation and Qualcomm about a patent for wireless handsets. Both parties design and sell wireless semiconductor chips. Qualcomm is probably the most successful developer and licensor of patent rights in the history of humankind, but in this case, they were the defendant. The patent is entitled Modular Portable Data Processing Terminal for Use in a Communication Network. Broadcom sued Qualcomm for infringement of this patent and won an injunction at an administrative body called the International Trade Commission, or ITC for short. I'm not going to talk about the ITC case. I'm going to talk about the appeal to the Federal Circuit Court in Washington, D.C. Broadcom sued for infringement of multiple claims, but the key claim was claim number one. In most patent litigation, cases are decided by the interpretation of a very small number of important claim terms or phrases, which I call key claim terms. In the case of Broadcom versus Qualcomm, the entire decision turned not on a phrase, but rather on a single word. Because of the interpretation of that word, Qualcomm paid out $891 million. If the word had been interpreted in another way, Qualcomm probably would have paid zero. Claim number one is relatively short. I'm going to read the entire claim to you. In this claim, one word was worth almost $1 billion. See if you can tell what the word was. I know it seems difficult, but it can be done if you understand certain principles of patent quality. Here's the claim. Try to spot the word. One or more circuits adapted for use in a mobile computing device, comprising 1. A terminal adapted to receive battery power for at least one of the circuits. 2. Communication circuitry comprising a reduced power mode and being adapted to use a first wireless communication and a second wireless communication different from the first wireless communication to transmit data to access points, comma, the communication circuitry reducing power by controlling the frequency of scanning for the access points. And 3, processing circuitry arranged to process data received from the communication circuitry. Did you pick up the key word? I'll give you a clue. The key word that was worth almost $1 billion is not a technical word at all. In fact, it's a common word that comes up repeatedly throughout the day in ordinary conversations. Does that help you? If you'd like, stop the video, go back and listen to my reading of the claim one more time to see if you can find the key word. Stop the video now. The key word is different. The entire phrase is a second wireless communication different from the first wireless communication. But everyone in the case agreed that the key word, the single key word, was the word different. You should understand what the parties argued, and I'll describe that briefly. The plaintiff, Broadcom, argued the word different means completely different air interface protocols. What's an air interface protocol? It's something like GSM, CDMA 2000, or LTE. It's ways that devices communicate together. Different protocols. The defendant, Qualcomm, argued no, the term different includes what Broadcom said, but it also includes systems that use the same protocol, the same way to communicate. So you understand what happened here. The patent owner said only different protocols. The party being sued said no, both different protocols and also two systems using the same protocol. What happened here? In the normal case, you would expect the owner of the patent who is the plaintiff, to say, my patent covers everything. It's very broad. It catches all kinds of infringers. And the defendant would say, no, the scope of the claim is very narrow and does not include me. But in this case, the parties argued exactly the opposite of what you would expect. Why did they do that? Because both parties, Broadcom and Qualcomm, understood that there was existing technology, what's called prior art, which overlaps communication using the same protocol. So that if the court accepted Qualcomm's definition, they would have to say, well, part of the claim has already been invented, and therefore we're not going to enforce that as part of the claim. But patent law says that if a claim includes technology that is new, but also technology that is not new, the entire claim will fall and the defendant will win. That's exactly what happened here. The conflict between these two positions represents a principle of patent law which I call claim validity and claim scope are natural enemies. That's the phrase. A claim that is broad, that is, it has wide scope, may catch many infringers, but it's also subject to being invalidated by a court when it goes to trial. On the other hand, a narrow claim that has a very small scope of coverage is almost certain to be validated or enforced by the court, but fortunately, it won't catch any infringers. So it's a valid claim that will not have any value because it doesn't catch infringers. If you're trying to decide if you have a good patent, you need to understand the balance between claim validity and claim scope. In the actual case, Broadcom versus Qualcomm, the court sided with Broadcom for reasons explained in the book, which I'm not going to get into now. But this case becomes extremely interesting now. On liability, Broadcom wins, but the court says the injunction ordered by the International Trade Commission is too broad. We're going to void that, and we're going to send it back to the commission to try again. In other words, Qualcomm actually won this round of litigation. But there were no other rounds of litigation, and Qualcomm very shortly thereafter agreed to pay out almost $900 million. Why? Well, there are two reasons. In patent litigation, in patent wars, there are many battles, and Qualcomm knew what would likely come up with the next battle, which wasn't good for Qualcomm. And second, and this is really the problem, Qualcomm did not really use its chips. It sold its chips to phone manufacturers who took the chips, incorporated them into their products, and sold the phones into the market. But if Qualcomm were liable because of the chips it made, then the users and sellers of products with the Qualcomm chip would also be liable. Can you understand the pressure that Qualcomm must have felt to settle this case? Let's look at it like this. Suppose that you personally are sued for a lot of money and you go to court. The judge says, you are not liable, but because of what you did, your spouse is liable, your parents are liable, your children are liable, your best friends are liable, your colleagues at work, and the guy you buy a newspaper from in the morning, they're all going to be liable when this case comes to trial again. But again, you're not liable, case dismissed. As you're walking out of the courthouse thinking about this terrible victory, the plaintiff comes up to you and says, let's make a deal. All right? If you will pay me a lot of money, but it's not something you can't afford. If you'll pay me, let's say, 3 months of the profit that you would normally make, I won't sue you, I won't sue your customers, all this will go away. And so you can understand why Qualcomm chose to settle this case. All of this came from the word different. Can you believe that? Is that something that you could have predicted? Patent lawyers often say that we do the best we can when we write patents, but we can never know for sure, and we can never predict all the words that will be key claim terms when the patent comes to trial in 5, 10, or 15 years. I'm a patent lawyer, and I agree with that comment, but not for the word different. Patent litigation often involves non-technical common words that everybody knows what they mean until it turns out that people don't know what they mean. And the word different is such a word because it's a comparative word. Words like different, similar, same must be explained in the patent. If I see one of these comparative words in the claims, but it is not explained in the patent, then I know that the patent has serious problems. From the battle in this case over the word different, we understand: 1, the natural tension between claim validity and claim scope. 2, the importance of explaining key claim terms. 3, different kinds of patent liability, here for Qualcomm and also for Qualcomm's customers. And 4, the extremely problematic nature of comparative adjectives in a patent claim. We discussed one issue in one patent taken from one chapter of the book, True Patent Value. The book has 20 cases, over 50 patents, and close to 100 lessons to be learned about patent quality and patent value. Thanks for your attention.